I'm Matt Bichard with NAREIT.com here in Phoenix, Arizona for REITWise 2015, NAREIT's Law, Accounting, and Finance Conference. I'm joined today by Melissa Lishner, Director with Crystal & Company, and Michael Chu, Vice President and National Practice Leader of REITs with Arch Insurance. Thank you both for joining us today.
Thanks for having us, Matt.
I understand there have been some changes made to NAREIT's D&O program. Melissa, can you start by talking about the process and the rationale that went into making those enhancements?
Well, obviously at Crystal & Company and with the NAREIT Insurance Committee, we're always interested in broadening the coverage that is available to the members. So about 4 to 5 months ago, the NAREIT Insurance Committee and outside counsel approached Crystal with a number of changes they wanted to discuss within the program. At Crystal, we added some of our own, and we then approached Michael and the rest of the REIT team at Arch to go over these possible changes. After a number of rigorous conversations and discussions about language and intent, we came up with what we feel are major changes to coverage that will be available to all current primary insureds and future primary insureds within the program effective immediately.
And Michael, could you elaborate on what the top 3 coverage enhancements are?
Sure, be happy to, Matt. Essentially, the new suite of enhancements contains nearly a dozen new features for NAREIT members. The intent really is to better address some of the hot button issues impacting REITs in the industry today. In terms of the top 3, the first I would say is, we removed the exclusion for plaintiff's counsel fees in bump-up litigation. So essentially, over the past few years, we've seen an increase in claims frequency surrounding the so-called bump-up litigation, litigation that alleges inadequate price consideration and breach of fiduciary duty. Essentially, these matters have accompanied merger transactions over 90% of the time. So with that in mind, we wanted to provide the members, with some broadened coverage in this area. The second is that we've affirmatively stated that plaintiff's counsel fees paid by the REIT in a derivative lawsuit are covered. So recently, one of the largest insurance carriers in the industry took a unique coverage position whereby they deemed those amounts to be corporate obligations and therefore not eligible for coverage under the D&O policy in a derivative situation. We do not agree with that unique position and wanted to specifically address that in the NAREIT D&O policy. And third, in response to the Halliburton versus Erica P. John Fund Supreme Court decision that came down last June, we're offering all NAREIT members a waiver of the retention for class certification event study costs. As a result of the decision, we feel that event study costs are going to be a larger part of the class certification stage in a securities claim. And to that end, the costs to defend securities class actions is likely to increase. In talking with Crystal & Company, NAREIT, and NAREIT's Insurance Committee, we wanted to provide NAREIT members with some additional assistance, flexibility, support in this area.
And what should NAREIT members who want to learn more about these enhancements or the D&O program in total do?
They should contact us to set up a meeting with their client, and we'll be happy to discuss all the changes that are available.
Great. Thank you both for joining us today.
Thank you for having us.
For more on this and other REIT news and analysis, be sure to visit REIT.com.